The law of contract is certainly a very interesting area of law. You will be very passionate, and you would want to know why and how does a contract come into existence. You might be entering into a contract with so many people in one single day, and you don't even realize it. When you're buying something at the shop, when you're buying something from the supermarket or from your drugstore, each and every time a contract is created. Obviously, most of the time there's nothing on paper, but it is a contract. A contract is basically made up of promises. Well, the promisor and the promisee. So the promisor will make a promise to the promisee. I promise to sell to you my house for 1,000,000 rupees. And you, the promisee, will decide whether you want to accept it or not. Now, today we are going to look at two very important concepts in contract law. One is the offer, and the other is acceptance. And it is important to note certain very important facts right at the outset. An offer is a statement by one party of a willingness to enter into a contract on stated terms, provided that these terms are in turn accepted by the party or parties to whom the offer is addressed. Now, there is an important difference between an offer and an invitation to treat. An invitation to treat is simply an expression of willingness to enter into negotiations, which it is hoped will lead to the conclusion of a contract at a later date. An invitation to treat is mere negotiations, and it is distinguished from a formal offer. Interesting case which talks about the difference between an offer and an invitation to treat is that of Gibson and Manchester City Council. Mr. Gibson made a formal application, leaving the price of that property blank because there were some uncertainties regarding the price of this property. Eventually, the council decided not to sell the houses to the existing tenants because there was a change in government and the new government decided not to go ahead with this plan. So the question which arose was whether the council had a binding contract with those people. It was held by the court that the council only had made an expression of their willingness to enter into negotiations with those tenants. Now, the display of goods for sale. You must have come across in supermarkets and in shops that products are displayed with a price tag on it. Now, have you ever wondered whether those products which are put on display are offers made to you or are mere invitations to treat? In normal circumstances, the display of goods for sale is considered to be an invitation to treat rather than an offer. And the main supporting authority with regards to that will be Pharmaceutical Society of Great Britain and Boot Cash Chemists. The main dispute in Pharmaceutical Society of Great Britain and Boot was whether drugs which were put on display in a pharmacy, which were not in an area under the supervision of a registered pharmacist, was in fact an offer. And it was held in that case that all drugs which were put on display were mere invitations to treat, so they were not considered as an offer. The sales actually took place at the cash desk and not from the shelves, and the display of goods were held to be mere invitations to treat and not a breach of the Impogne Act, which was the Pharmacy and Poisons Act, which required that every sale of a controlled drug had to be made before a registered pharmacist. Another contentious area of the distinction between an offer and invitation to treat is newspaper advertisements, and you will come across them every day of your life. Every day you will see someone wanting to sell something or advertising something at a certain price in a given newspaper, be it in Mauritius or anywhere else in the world for that matter. Now, what are those advertisements? Are they offers made to you, or are they mere invitations to treat? Well, the more reasonable approach to it would be that they are invitations to treat, because considering them as offers would create big problems, given the fact that an advertisement in the newspaper is addressed to almost the whole of the nation. And just imagine if an offer was made via a newspaper, what kind of disaster that would be if everyone were to accept this offer. Now, an important authority which makes the distinction between offers and invitations to treat with regards to newspaper advertisements is Patridge and Crittenden, 1968. Now, in that case, the Birds Act 1954 made it an offence that certain birds were offered for sale, and any bird which was offered for sale was in contravention with the Act, with the Birds Act 1954. And eventually someone advertised in the newspaper that there were certain birds which were for sale. Now, since offering those birds for sale was in contravention of the legislation, the question to be resolved was whether an advertisement in the newspaper of those birds amounted to an offer. Now, it was held in that case that advertisements in the newspapers were merely invitations to treat and not an actual offer. So the general rule was then formulated that newspaper advertisements are mere invitations to treat and not offers. However, there's an exception to that. An important exception to the general rule that advertisements, in fact, do not amount to an offer was created in the case of Carlyle and Carbolic Smuggle, where it was in fact held that advertisements, that particular advertisement was treated as an offer rather than an invitation to treat. There was a long debate as to whether the advertisement of Carbolic smoked balls was actually an offer or an invitation to treat. In fact, in Carlyle, there was a smoke ball which was being advertised in a newspaper, and the advertisement was such that if ever someone contracted a certain disease, even after having consumed the smoke ball, then the advertiser would pay that person a certain amount of money. And effectively, someone indeed consumed the smoke ball, used the smoke ball, and contracted that illness. So the question was whether the advertisement in the newspaper amounted to an offer which was accepted by that person, and the court actually held that the advertisement was actually an offer which was indeed accepted by a person accepting to buy that smoke ball. So this is one exception to the general rule. You must have heard about auction sales as well. Now, auction sales are very common both in Mauritius and in the UK. What happens with an auction sale is that the auctioneer invites bids to be made, and then the person will tender his amount or will bid for a certain amount. Now, it is the law that an invitation for bids is in fact an invitation to treat, and the offer is actually made by the person tendering the bid or offering his bid. So much has been said about offers. Now let's look at acceptance. What is technically an acceptance? Now, an acceptance is an unqualified expression of assent to the terms proposed by the offerer. So we need to bear in mind two things. Unqualified expression of assent. It needs to be unqualified to all the terms proposed by the offerer. Because if you have any problem with all the terms or any of the terms proposed by the offeror, then what you suggest after that to the offeror will be akin to a counter offer and not an acceptance of the actual offer. So you become the offeror then. So let's say somebody's bidding, well, not bidding, somebody wants to sell his house to you, let's say at a price of 100,000 rupees. But you want to bargain on that price, so you call him up and say, I think I'm willing to buy the house to, let's say, 90,000 rupees. That would be in fact a counter offer and not an acceptance of the offer. So remember, it has to be an unqualified expression of all the terms of the offeror. Acceptance can also be by conduct. We've just seen that before in the case of Carlyle and Carbolic smoke ball, where the acceptance of using that smoke ball and by using it is actually a conduct, and the conduct amounted to an acceptance. In the case of Dame Morris Associates and Voice, it was held that conduct will only amount to acceptance if it is clear that the offeree did the act in question with the intention, objectively assessed, of accepting the offer. Acceptance must be communicated to the offeror. Acceptance can only be valid if it is communicated to, or if it is brought to the attention to the offeror. And that was held by Lord Denning in Antorus and Miles Far East. Have you ever wondered whether silence will amount to an acceptance? Someone makes an offer to you and you remain silent. Will that amount to an acceptance? Well, more logically so, it should not amount to an acceptance. And there's a very good reason to that. What if tomorrow an offerer puts a term in his offer that should you not reject this offer, you will be considered as having accepted it? So even if you were not willing to accept this offer, you'd still be bound by a contract. So would that be fair? Of course not. So that's why silence doesn't amount to acceptance of an offer. And that was held in the case of Feldhaus and Bindley, 1862, as early as 1862.